Can I discharge student loans in bankruptcy after divorce? If you are facing a divorce and wondering about your student loans, you are not alone. Many people find themselves in similar situations. A common question that arises is whether you can discharge student loans in bankruptcy after a divorce. Let's break this down step by step. First, it is important to know that student loans are generally considered non-dischargeable in bankruptcy. This means they usually cannot be wiped away through bankruptcy proceedings. However, there is an exception. If you can prove that repaying the loans would cause an undue hardship, you may have a chance at discharging them. Now, when it comes to co-signed student loans, things can get a bit tricky. If you and your former spouse co-signed a student loan, both of you are responsible for that debt. This holds true even if your divorce agreement states that one person is responsible for the loan. The lender can still pursue both parties for repayment, which can lead to complications during and after the divorce. If you decide to pursue bankruptcy to address your student loans, you will need to file an adversary proceeding. This is a separate lawsuit within your bankruptcy case. In this proceeding, you must prove that repaying the loans would cause an undue hardship. The court uses a three-part test to evaluate your situation. The first part of the test is about maintaining a minimal standard of living. You need to show that repaying the loans would prevent you from living at a basic level for yourself and your dependents. The second part looks at the persistence of hardship. You must demonstrate that the circumstances causing your hardship are likely to continue for a significant portion of the repayment period. Lastly, you need to show that you have made good faith efforts to repay the loans before seeking discharge. Divorce itself does not directly affect the dischargeability of student loans. However, it can impact your financial situation. For example, if your income decreases after a divorce, you may have a stronger case for proving hardship. This change in your financial landscape can help you argue that repaying the loans is not feasible. If you are considering bankruptcy to deal with student loans after a divorce, it is wise to consult with a bankruptcy attorney. They can guide you through the process and help you determine if you qualify for an undue hardship discharge. Understanding your options is key to making informed decisions during this challenging time.